former Fulton County District Attorney and Sheriff.
Formerly a judge, and he knows a little bit about how these things go.
From Mohawk Valley, legal eagle, lawman.
He is the Sheriff of Fulton County, New York. Just such an amazing guy.
This is the Rich Giardino Show, where the Constitution, crime, and politics meet.
I'm Rich Giardino. I have a podcast called Constitution, Crime, and Politics and Where They Meet. It's a discussion of criminal matters and the Constitution and politics, how they intersect. We have a guilty verdict in the Donald Trump trial. Guilty verdict simply means that all 12 of the jurors found that the district attorney proved their case beyond a reasonable doubt. The next step is for the defense to make a motion to set aside the verdict. Now, that's different than the trial order or dismissal motion that the defense makes at the end of the people's case and at the end of all the proof. So that was called the trial order dismissal. And this is called a motion to set aside the verdict. So what happens at this stage, there'll be an adjournment for quite a while till they can get a transcript, because defense and DA are entitled to a transcript so they can make their factual and legal arguments as to why the verdict should be set aside by the judge. Based upon the fact that the judge let it go to the jury and denied the trial order dismissal, I do not believe that the judge will set the verdict aside. After he makes a ruling sustaining the verdict, the next thing that will happen is President Trump will be sentenced. There will be the ordering of a pre-sentence report through his probation department, and they'll make a recommendation. This is a nonviolent felony, along with some other charges, several charges. The highest is a pre-sentence investigation will be ordered through probation department. Since the charges are nonviolent felonies and misdemeanors, they will look at the defendant's lack of a criminal record. They'll look at the specific charges in this case. They'll look at the age of this case, how old the allegations are, and they'll make a recommendation. Generally, an individual, even on a felony conviction, if it's nonviolent and they have no prior record, we'll be looking at probation, community service, or a fine. So in this particular case, we don't know what the probation department will recommend, but the judge is not bound by the probation department's recommendation. A judge can accept it, reject it, and render his own sentence. Both parties will be heard. They'll both do sentencing memorandums, the defense and the prosecution. And it'll ultimately be up to the judge. Mr. Trump, President Trump, will be given an opportunity to be heard before he's sentenced, directly, not with the attorneys, and after he's sentenced. He'll be asked by the judge, do you have anything further to say? Once the sentence is incomplete, in this case, there will probably be an application for what we call a stay. A stay is to stop the sentence from being imposed. So the sentence is imposed, but I'd say executed, stop the sentence from being executed. The defendant will not be sent to jail or prison or probation. Everything is on hold until the appellate courts make a ruling. So that's what we call a stay. So that generally happens in most criminal cases that are nonviolent and no prior record. A stay is generally granted. In this case, there's so many issues to be litigated, from the fairness of the judge, whether or not, even though the Judicial Commission has said a $35 donation to Biden and other Democratic donations is not a wise thing for a judge to do, but it did not prevent him from presiding over this case. But an appellate court will look at it, and they may make a different determination. There's also the issue of the judge's daughter making millions of dollars, raising millions of dollars based on the fact patterns before the judge, and whether or not that rises to the level of a conflict for the judge himself. They're also going to look at Cohen tape recorded conversations with his client, President Trump. And the question is, was it ethical and legal for him to tape record the conversations if he's representing a client? Because we have an attorney-client privilege, that issue will be relitigated. The testimony of Stormy Daniels and Cohen will be looked at for credibility and believability. Generally, the appeals court leaves determinations of credibility in the hands of the jury, but they may find that some of the testimony should have been struck, means not allowed in. and they may determine that as a matter of law, the witnesses are incredible. Generally, they don't do that, but it'll go up to the appellate division. From there, it could go up to the Court of Appeals, which is the highest court in New York. But there will be no decision from appeal on this case until after the election, well after the election, probably. It's going to take several months for them to do their arguments, get the paperwork together, and have responses. Again, a guilty verdict served two ends. If you want to argue that it wasn't political, we weren't in the courtroom. We didn't listen or watch every day. I didn't read transcripts every day. So ultimately, the jury determined that the testimony was credible and believable, and the people proved their case beyond a reasonable doubt. That's politically, if you thought it was a political prosecution by the defense, by the prosecutor, if you thought it was a political decision by the prosecution to move forward after the feds had said they weren't going to pursue these same set of facts, then it's a win for the prosecution, because not only did they muddy Donald Trump, they tied him up for 4 weeks, and they succeeded in getting a guilty verdict. Stay safe, and we'll see you next time on The Rich Giardino Show.
Like and subscribe to The Rich Giardino Show, part of the Elite Influencer Network, wherever you get your podcasts. And we'll see you next time on The Rich Giardino Show, where the Constitution, crime, and politics meet.